Good morning, everyone.
Good morning, sir.
Good morning, sir.
Good morning, sir. Good morning, sir.
We'll be starting the guest lecture by Senior Advocate Sir Salman Khurshid in a short while. So I request everyone to kindly switch off or put your mic on mute. Although I'll do it from my end, but some of you who have the facility by default to switch it on, I would request to keep it switched off so that there's least disruption. I have been receiving a lot of requests, my dear friends, for the link towards this lecture, and a lot of law students, lawyers, friends have been looking forward to it. And hence, please tell your friends now that I am making it Facebook Live. So anybody who wants to watch, I have sought permission from Mr. Khurshid, and sir has kindly agreed to allow me to make it live. Good morning, sir. Welcome. Can you hear me, sir?
Yeah,
are you able to hear me, sir? Yeah, you are live, sir.
I can't hear Nachiketa. Can't hear you yet.
Okay, I can hear you. Somebody has to set it up, maybe there.
I can hear you now. It's okay.
Okay.
I can hear you.
You can hear me, you can see me, right, sir?
I can see you, I can hear you. So tell me when you want to get started.
Okay, we'll just wait for another 5 minutes, sir. Few more participants are going to join in.
No problem. No problem.
And with your kind permission, sir, I have made it Facebook Live. I was receiving a lot of requests in the last 2 to 3 days.
That's okay. No problem. No problem. Hello, morning. Assalamu alaikum. Good morning, आयशा अभी हम एक लेक्चर करने जा रहे हैं फेसबुक पे, तो 11 बजे तक आप लोगों का पास वहां मिल जाएगा फर्रुखाबाद में, ठीक है ना? तो जैसे वो पास मिलेगा उसको नेट पर डालकर और उनको हरियाणा भेज देंगे, और मिसेस मान के यहाँ से जो आदमी उसको फॉलो अप कर रहा है उसको भेज देंगे। तो Good morning, Anshu.
Good morning, sir. How are you?
How are you doing? I'm well, thank you. Are you doing all right?
Yes, I'm all right. Thank you.
I hope we can get back to work soon. Let's see.
Me too, sir. Missing office so badly.
And that's Roshni. How are you doing, Roshni?
Good morning, sir. How are you?
Good morning. Nachiketa, this seems like a in-house gathering.
Okay. Yeah, a lot of your students, a lot of your colleagues, they have been requesting, and they have
I
joined
know, it's
several
useful.
places. Yeah, I was really happy to do this. So just so I think we can start now from here. Then it's 10 o'clock. So good morning, my dear friends. I am really happy to have Salman sir with us today, and sir has been kind enough to accept my request. Ever since I started off with this initiative of virtual law school. So I have briefed sir about it, and sir gave his kind consent to come and lecture for all the law students of virtual law school, especially on the subject matter of how judges decide cases. And I did mention it to sir that I am teaching the course on interpretation of statutes, and this will squarely fall within that domain, which is very large and encompassing in itself. So although apart from that, there have been a lot of students who wanted to attend sir's class, so I have, sir, allowed it more than, from the virtual law schools to everybody actually at large. And in keeping with that request and sentiments, and honoring all the friends, I am making a Facebook Live as well. So the ones who are attending these with us, registered with us at the moment, they can pass on the message to their friends that they can go and check my Facebook profile and can attend the lecture from there if they were not able to get registered or get the Zoom link for this lecture today. So on that note, sir doesn't need an introduction. Sir has been a accomplished lawyer, senior counsel in the Supreme Court for several decades, has been the Minister of Law and Justice, Minister of External Affairs, and so many hats sir has been wearing for several years, being in the bar or even in the government setup. And sir, one of the very interesting points which I really wanted to apprise, everybody knows it, but I wanted to put it in a different way, that when I was telling my students that this is a lecture on how judges decide cases. So I started off, in the classes with Benjamin Cardozo, Max Reddin, Joseph Reyes, Frederick Scheuer, and so many philosophers, and telling them with the perspective. But one of the very unique features now with your lecture is going to be that you have been in the Indian bar, you have known how the bench functions, you have served very closely with the courts. At the same time, you have been a lawmaker. So that is a very unique combination for a teacher to bring in, that how judges decide cases, because that's a perspective which certainly I cannot bring in to my students, not having served at the bar or been a lawmaker. So that's something I'm really looking forward to. In fact, all the students and all the participants, because that is a blend which only you can now bring on board to us. So on those words, sir, and on that note, welcome for this lecture, and thank you. Over to you, sir.
Well, thanks very much. I just get an idea. How long would you like me to speak? Because then I assume there's some questions to the end of it. So,
okay. So I think 45 minutes. Okay.
Yeah. Okay. 45 minutes.
Yeah.
And you can take questions after that. Yeah.
Right.
Okay. Good.
Good morning,
well,
sir.
Welcome everyone. I hope.
Yeah.
Sorry. Yeah.
Justice Sikri has joined in. So welcome, sir.
Thank you very much. Thanks very much, and delighted to be with all of you. This is a wonderful new step that you've taken for virtual law school. Kind of a look into the future, in a sense. We've been arguing or presenting our arguments online before the Supreme Court, as well as before the high courts, and that's been quite an experience. A lot of people are uncomfortable with it because it takes a little time to get a feel and to be confident enough that you're as effective online as you would be face to face with the judges in court. Be that as it may, this is a good start, and here we go. I've had the opportunity to speak online in the last couple of weeks on similar subjects or related subjects, and this would, in a sense, be a rerun of some of the thoughts that I presented to people. When we speak of judges deciding cases, I think it's important to understand that it's not something that's entirely different from our personal experience of how we make choice in everyday life, in the way we think, in the way we order things for ourselves, in the way we take positions on whatever may be happening around us in the country, in our family, in our society, in our homes, etc. There is always a method, sometimes perhaps explicit and sometimes implicit method, sometimes expressed, sometimes implied, a method by which we come to a conclusion. Now, in that method that we come to a conclusion on subjects, there may well be many factors that are relevant. Factors like what we call intuition. Now, intuition is a subject by itself, but let's assume today that intuition is an element that prods you or that persuades you kind of naturally and automatically to take a particular position. There is also what we call conditioning, what we the situation in which we grow up, the experience that we've had, the events of our life, what we have learned from them. Life is a great teacher, as we all know. What we have learned from them, the manner in which we have been taught at home, modes of behavior, modes of conduct, etc., are all part of the backdrop in which we take a decision. So there's intuition, there is conditioning, there is in the natural course the capacity and ability of every human being, and particularly those who have been instructed, who've been taught, who have learned the scientific methodology of observation, analysis, conclusion, etc. You put all that in, and then you get a decision. Now, there is no reason why this should change when you become a judge. Judges, after all, are, as we know, from amongst us, from the bar. Someone becomes a judge, or someone who has qualified as a lawyer and has some experience, sits an exam, and from the exam they get selected, get on to do some training. Now we have now the judicial academies everywhere. They go through some training from experienced judges and then move on to become judges themselves. Now, so as I said, there is no reason to think that a judge is different from an ordinary person in terms of the inputs that go naturally into the decision-making process of the judge. But it's quite possible that the training of the judge and the cognition, as it were, and self-consciousness in the best positive way of a judge makes the judge remove some of those factors and elements consciously in order to be objective, whatever that objective means, i.e., that you do not decide something merely because you have a personal like or dislike, a personal prejudice or inclination, but on the basis of some objective standards accepted institutionally or accepted in terms of your social standards, etc. And that's what training is about. It's like training of any professional, that you have elements of what would be naturally there in any human being, but that you remove some which you think are not necessary or relevant for your professional work, and you include some or amplify some which your professional training requires you to do. And that may well be the case of a judge. Having said that, let us see what are the issues that arise and in manner in which they arise before our modern society. There are issues that are constantly on a regular basis taken up, and on which positions are taken by legislatures, by parliament, for instance. So when parliament makes a law, and that's the basic job of parliament, is to make laws and, of course, to, in a sense, supervise the implementation of those laws in terms of how government performs in the implementation of those laws, etc. But essentially, Parliament's job is to make law, is to legislate and to make law. What does Parliament do in making law? What does a legislator do in making law? What does the legislator or Parliament look at in making law is very fundamental, and that is what distinguishes Parliament or a legislator from a judge or an adjudicator. And I think let's keep that in mind. So when Parliament is making law, Parliament looks at essentially not what is an existing law, except to the extent of the Constitution, which gives Parliament both the capacity, the entitlement, as indeed the constraints and restrictions that are to be imposed on what Parliament can do. And we'll come to that question a little while later. So Parliament has the backdrop of the Constitution, which is also the basic document by which Parliament comes into existence, and therefore Parliament must remain and remains conscious as to the constraints imposed by the Constitution. Now, this may be different in a place like the UK, where we have been taught that Parliament is supreme and there is no constraint on Parliament, and Parliament can do what it pleases. But that's not the case where there's a constitution. Parliament can only do what the constitution permits. So what does Parliament actually do? What kind of exercise does it go through before legislating? Parliament does essentially what has been called by the famous jurisprudent, who in fact was my teacher, who lectured to me in Oxford University, Ronald Dworkin, sadly passed away 2 years ago. I believe the most brilliant mind of our times. According to him, Parliament looks at policy. Policy being a general proposition stating as to what would be the right thing to do, the good thing to do, the better thing to do, the maximizing thing to do for any society. So what would improve matters in society? What would put greater restrictions on unwholesome things in society? What would be the preferred thing that would please the largest number of people in society? These are questions that you would deal with when you are deciding to legislate. And that's policy, the area of policy. Policy may have certain inbuilt biases or inbuilt inclinations which deal with the other element that I will come to, which is the element principle that applies to adjudication. So policy is not entirely something malleable in the sense of saying, well, we can do this and we can do that. Most countries, most societies, and most systems would have an inherent constraint within policy, perhaps because of historical background, because of people's consensual approach towards what kind of life they must live. But broadly speaking, policy is something that creates a situation for the future. The moment legislation is passed, it becomes law, going through the procedures that are required, and it creates new entitlements. And it's generally assumed by courts that law is prospective. It looks to the future. It doesn't look to what has happened in the past, particularly if happens to be a law that imposes criminal culpability or criminal liability. In very special circumstances, the law may be permitted to look at something of the past and impose some obligations, but I think it's very unlikely that constitutional courts would uphold something of that kind, where obligations are imposed for something done in the past, which when done did not have those obligations. So let us, for a general proposition, accept that legislation is forward-looking, is prospective, and creates entitlements or imposes constraints for the future. That's what legislation is about. That's what policy is about. And policy looks at what is an objective to be achieved, what is a purposeful intent that one prefers for society, and how we want to take people in a particular direction. It may be by people's consent, it may be by without people's consent, because when you come to parliament, when you're a leader in a democracy, your job is as much to lead people in a direction that you think is the correct direction, rather than merely led by them when they think something ought to be necessary. Although the majority idea, the rule of majority in democracy obviously entails that the opinion of the majority, the desires of the majority must be taken very, very seriously. Now let's look at the other side. Let's look at adjudication. Now in adjudication, taking the broad structure of adjudication and how judges decide cases, it is not like policy. It's based on something called principle. Now, of course, the judge's role is in a sense facilitated by what Parliament writes for the judge to say, this is the law, please apply this law. So if some issue comes up, all the judge has to do is to find the appropriate legislation, look at that, read it carefully, and come to a conclusion as to what entitlements people have, given that there is a particular adjudication for a particular conflict of interests or conflict of claims between parties. That's available. Another thing that's available to the judge is judgments of judges of the past, what we call the stare decisis or precedents on which the judge can rely. So a judge can often say, the law on this is clear, I have to follow that law, because another judge in the past has already stated this is what the law is. Now, of course, there can be a departure. There are cases and there are circumstances in which a judge would say, the judgment that was given earlier was a mistaken judgment. It was an incorrect reading of what the law was, i.e. what the legislation was. It was an incorrect interpretation of the word that has given direction to the earlier judgment. And this is, as Mr. Mittal had mentioned, in statutory interpretation, there are certain instruments or there are certain techniques utilized in order to come to a conclusion as to what is Parliament saying, what has Parliament meant, what was Parliament intending to do. There are many ways in which you can look at, and there are some very technical, some very general rules by which what Parliament intends to do or what Parliament means to say or what Parliament has said is finally ascertained. And that's done by judges as well. It's done by academics, it's done by judges. And therefore, it's open for the judge to say, looking at all these instruments and all these procedures, the judgment that I am supposed to be bound by is clearly incorrect because the interpretation was incorrect, and therefore I will depart from it. I would overrule it. Of course, you have to be a larger number of judges to overrule lesser number of judges of the past. I will overrule it, and I will set the law straight. I will give the correct interpretation, and that will become the law in the future. Now, that's a relatively easy exercise for a judge to do. But in saying that the earlier judge was wrong and that we are correct, the present judges are correct, what is it that really allows them to do this or allows them to say this? In doing this, do they go back to policy? Should they just ask for public opinion? Should they just have an opinion poll? Should they just have a drawing of straws and then decide, well, this was wrong because the opinion poll says this was wrong. This was wrong because people now believe that this was wrong, and therefore I just have to follow. This is not what the judge is supposed to do. That's what a legislator does. To get elected, he needs to know the opinion of his constituents, and by and large, unless of course he has a very special exception, which is a principled exception of what you call a conscientious position that's taken on something where the legislator would go against the popular will, the judge cannot do this. The judge has no option but to decide sitting in his chambers, sitting in his courtroom, and not coming out into the streets to ask people what is it that should be done. Now, we don't even have any more in our country the jury system as far as criminal law is concerned. So there is no jury, there is no representative of the people, as it were, out there telling the judge what the preferred choice would be. And therefore, the judge must decide everything on his own. Now, how does he do it? Policy is not available to him. Though policy may inform his decision, he may take into account that the policy is not entirely irrelevant. It is relevant because, after all, whatever decision is taken, whether by parliament or by courts, must be a decision that is an improvement for society. That is a decision that is welcome to society or wholesome to society. And therefore, elements of policy may actually influence the decision on principle. But the decision on principle, dominant factors of the decision on principle have to be entirely different. Now, what are those factors and how do you decide those factors? That's where Ronald Dawkins says principle comes in. Now, what is a principle? Principle can be an articulation of an instinct. Principle can be an articulation of a popular policy or preferred policy. Principle can be an articulation of an ideology. Principle can be an articulation of a deep-seated belief of moral or ethical nature. Principle can be conditioning, etc., that I spoke of. Now, all those again cannot be the final and the conclusive element in the decision that needs to be taken if the judge is to do his job properly. And how does then a judge decide what is the right things that the judge has to do? The judge looks for something called what is the principle involved, and that principle is to be based on shared values about how human beings conduct their affairs. And these shared values are not like popular morality. Morality is, after all, like law. Morality also is a code of behavior, which is not merely descriptive. It is normative. It is something that you feel bound by. It also has, to some extent, institutions or systems by which sanctions are imposed for violation of that morality, etc. So that morality is, in a sense, the idea of shared values of a society. But shared values of a society are not shared values of today alone. It isn't that the judge can do an exercise by which he can discover or he can articulate what is today the shared value amongst people. So let us test this on a proposition which is still completely open, in a sense open in our country, but which has been finally decided one way or the other in more than 110 countries in the world, and that's capital punishment or death sentence. We have in our country the proposition, the law as it stands today is that it's only in rarest of rare cases that death sentence can be imposed. Merely because somebody murders someone else, it doesn't mean that he will get death sentence. It could be a life sentence. It could be less than death. And death sentence can only be imposed in what the judges have said in Bachchan Singh as a rarest of rare case. Now, of course, that is an unusual phrase, rarest of rare. And rarest of rare is what the judges have said. We will not exhaustively tell you, but we will tell you in certain kind of circumstances, we would consider it to be rarest of rare cases. And they have justified rarest of rare cases death sentence on grounds such as it would be specially necessary to eliminate a very peculiar and a very, very great danger to society. It would be circumstances in which some kind of reaction is permissible because of the very horrendous nature of the crime and so on and so forth. Now, those reasons generally, frankly, if you ask me, apply to any case of murder, any case of murder, except in a case of murder that shouldn't be a murder at all, which may well be where the mens rea is lacking, at least to the extent that it could be defined as murder. If it's something like culpable homicide not amounting to murder, then you don't need to go into the exercise of rarest of rare at all. But how does the judge look at all this? Simply follow what earlier judges have done? Then if the earlier judges were to be followed, then where did the rarest of rare qualification come in? Some judges, a generation of judges, rarest of rare to something that did not have rarest of rare. For murder, they would just generally opt for death sentence. But now they have made themselves very restricted. Their opinion has been very carefully articulated to leave a very narrow path for death sentence. So if the judges of one generation can write the gloss of rarest of rare cases, the judges of another generation could say that death sentence in principle cannot be upheld in our country as it is being held void in 110 other countries. But how do they approach this? Now, their approach has to be based, again, we go back to the original distinction, either on policy or on principle. If it's policy, then they get data and they decide, will we be better off with death sentence? We will not be better off with death sentence. And these kind of arguments, we often hear every time some gruesome attack takes place on a child or a woman. We hear when a gruesome attack takes place in which somebody is martyred, a soldier of our country is martyred in the defense of the civilians of this country. We hear these arguments, but these are arguments of sentiment or arguments of policy, perhaps at best arguments of policy. These are not arguments of inherent principle of shared values of our society. You can't go and take a public poll and say, well, this man has martyred our soldiers, should he be executed? Of course, a lot of people will say he should be executed. But that's mob justice. That is not adjudication. That is not what we mean by judging and deciding on principle. Therefore, the judge needs to look at something else. He needs to look at institutional history of our society, i.e., how shared values have persisted over a large period of our history, and how those shared values have transformed our society or have directed our society in a particular way. That's what the judge has to look for. And of course, his fundamental basic material will be what the law provides, i.e., he will look at all the previous judgments. But in reading the previous judgments, the judge will be conscious as to how those previous judgments were formulated. And there the judge would examine whether those previous judgments themselves had looked at shared values of the past, or those previous judgments were in fact only reacting to popular sentiment. Therefore, not popular morality, not popular values, but institutional morality and institutional values is what the judge will look at. Now, for this exercise, which is in a sense a larger than life exercise, a exercise that for an ordinary human being would be difficult, would be very trying. The author, i.e., Ronald Dworkin, has called this judge Hercules. No ordinary man, no ordinary person, no ordinary woman can perform the job that Ronald Dworkin's judge has to perform. And that's why Ronald Dworkin's judge is called Hercules. The other judge, the judge who doesn't know all this, who doesn't do all this, mischievously and ironically, Ronald Dworkin called Herbert. And Herbert being the first name of Herbert Hart, H.L.A. Hart, who was Ronald Dworkin's own professor, professor of jurisprudence at Oxford. And Ronald Dworkin succeeded his teacher as professor of jurisprudence at Oxford. But obviously, he disagreed fundamentally with what the H.L.A. Hart positivist thesis was about adjudication, and therefore gave what he called the rights thesis. And the rights thesis was first mentioned in the inaugural lecture of Ronald Dworkin, which was called Hard Cases. And we as lawyers know that hard cases make bad law. This is what we've always been taught. Why does it make bad law? Is because the very ingredients, quite right, you got that. And thank you very much. That book Mr. Mittal has is a book where this whole story starts, and I recommend very strongly that all of you get a copy of this book. It's called Taking Rights Seriously. And maybe on another day, we will take up some recent cases of the Supreme Court, including the Anuradha Bhasin case, in which restrictions placed on public places under Section 144 have been balanced with the compulsions of national security, restrictions placed on the internet. And that matter has been argued again recently, 2 days ago. The judgment is reserved that restrictions placed on the internet, reducing the speed from 4G to 2G, whether obviously in the face of national security, would that be permissible? And Ronald Dworkin, one man who would have said that this is not easy if you believe in rights, and that's why he calls it the rights thesis, taking rights seriously. So he says that if you take rights seriously, you can't just take one thing and say, well, these rights all go out of the window because there's national security. There has to be a very persuasive argument to convince Ronald Dworkin that rights can be curtailed. For instance, we often believe that there is right to free speech, but we create some restrictions when it comes to offending speech. And often people believe that you have a right to free speech as long as you don't offend another person. Ronald Dworkin says that if you do not have the right to offend, then the right has no meaning at all. You have a right of free speech when everybody is happy with your speech. Of course, there isn't anything interesting in such a proposition. It's only when people are unhappy with your speech that your speech or your right to speech becomes important. So here is a approach to rights which I believe is very, very interesting, and particularly in our times when there are contested claims of the state versus the citizen, etc. This would be very rewarding reading. But let's get back to Hercules, the judge who has to look at institutional morality and come to a conclusion. Now, there is nothing about Hercules that says that what Hercules decides is the right answer. It's not the right answer necessarily, because Hercules, despite being called Hercules, still has faculties that are human. He may have made a mistake. Earlier judges that he reads as having correctly decided may have made a mistake. So there is a theory of mistake as well. And I think that theory of mistake, we all understand. Why do the courts of the country periodically come to a conclusion that something that seemed very, very firm and very, very fair suddenly seemed completely unacceptable? Take the Nas Foundation case, for instance. LGBTQ rights were considered no rights at all. And suddenly, indeed, they were treated as criminal offenses. And now suddenly, the Supreme Court, first the Delhi High Court under Chief Justice A.P. Shah, then the Supreme Court, first rejecting the idea, and then in a review, accepting the idea that consensual conduct between adults cannot be made a crime. And therefore, we can see how judges have changed from one position to another. Has this been done because we believe that our policy considerations have changed, that policy considerations give us a different answer today from the one they gave during the time of British judges and during the earlier time of the Supreme Court, etc.? Have the policy considerations changed? Or has the Supreme Court come to a conclusion that the earlier judgments were wrong? They were wrong because they didn't correctly reflect the shared values of our society, and have come now to a different conclusion entirely. Although they've come to a different conclusion, we still know that it would not be legal in this country for people of the same sex to tie the bonds of marriage. They could not be a couple. Elsewhere in the world, in Europe, in the United States of America, certainly certain states of the country there, people are able to join in marriage, even if they are from the same sex. But that's not yet the law in our country. We can say very clearly that is not the law in our country. Either Parliament will have to create that law, or in a subsequent judgment, the Supreme Court will come to this conclusion. Let's look at another example. Let's look at the example of two books that were proscribed or banned in our country, first being Lady Chatterley's Lover. Now, there is a remarkable gathering of Supreme Court judges, profoundly intellectual Supreme Court judges, including Chief Justice Hidayatullah, who decided that the ban was permissible. Subsequently, a ban of a kind was imposed on satanic verses many, many years later. It never got questioned by courts, but it was assumed that it was a ban that might have been upheld by the courts at that time. Today, if Lady Chatterley's Lover comes back to court, if satanic verses comes back to court, it cannot be said with any certainty at all that the Supreme Court will take the same position as it took then or could have taken then. The Supreme Court will certainly, given that the recent judgments in privacy, given the recent judgments in which Justice Chandrachud has actually overruled his father's judgment in ADM Jabalpur, where rights have been taken somewhat strongly, much more strongly than we had seen rights before. I'm not quite sure that Lady Chatterley's lover would get the same treatment by the Supreme Court today as it did several decades ago. So why is the Supreme Court changing its mind? Is it policy or is it further investigation? So come back to what I said. At any given time, the answer that the court gives, even when it is searching for shared values, is not an answer that can be said to be the right answer or to the last answer, but it is only the best answer given in the circumstances that were available, in the knowledge that was available, in the research that was done, but leaving open the possibility of even better answer in the future when more research is done, when more information is available, and more reflection is possible. This is akin to scientific experience. What is the scientific experience? You cannot say in science, if you're a serious scientist, that you have the right answer. All you have is the best answer, because you've done observation, you've done experiment, or you've done experiment and observation, and then you have drawn a conclusion. That conclusion may be a wrong conclusion, it may be a right conclusion. But even if it's a right conclusion, it's a conclusion based on the experiment that was done. More experiments are possible. The observation that was made, better observations can happen. More material can be made available. More research can be done. And therefore, what seems to be the right answer today may well be the wrong answer for a better answer tomorrow, which tomorrow would be considered the right answer, but it will not really be the ultimate right answer. It is the method that matters, not the conclusion. The conclusion can change from time to time, but the method must remain that you continue to search for the right answer. You may not get the right answer, but the method itself is important because it's part of a link, is part of a process by which the right answer will one day finally happen. Sometimes, because we are, and certainly in the UK and the US, many judges were accustomed to not making this clear distinction between policy and principle or shared values. And therefore, students too, during the time that I was a student at Oxford, would get very confused and look puzzled. And then Dworkin would say to them, imagine that there is a painting on the wall. And that painting is 6 feet by 4 feet, but it's got a border. Inside that border, the painting has a very beautiful valley with a brook running through it. There are 3 or 4 horses walking along the path. There are trees in the backdrop. There are hills, and on the hills there is ice, and so on and so forth. Now, he says, if you come to the end of the painting at one end, one border of the painting, and I ask you, what is there beyond this border? What would be your answer? Now, some people will say the brook goes all the way to the top of the mountains or at the bottom of the mountains. Somebody else will say this road travels to a nearby hill. Somebody else would say there are more horses up ahead, or somebody else would say there is a little house up ahead, etc., etc. Now, all that could be imagination, and obviously was imagination. All that could be possible also if somebody quietly went and asked the artist, what were you intending to do, or what did you have in mind beyond this border? If you had a larger canvas, what would you have painted? And the artist could have said, this is what I thought I might do, but then I ran out of canvas, therefore I didn't do it. If I get another canvas, I will continue with this. And you have seen some great artists who paint in 2 or 3 separate canvases that can be put together to make one large picture. Now, Dworkin used to say that you may not always have the artist available to tell you what he intended to paint. But what you will have is a lot of information from critics, from historians, art historians, about the manner in which he used to conceive his paintings, the manner in which he used to use the brush and color, the kind of flow there was in his paintings. And you could tell that there was an inherent theme in the painting that would help you project what the painting would look like beyond the border. And that's basically how you work as you create new law. You don't know how an existing law would apply to a new set of circumstances, a blank board, as it were, or a blank canvas beyond the border. And how would you then show the picture continuing there so that there is no clear break from the picture as it exists, that there is some integrity and some thematic consistency, and there is, of course, a purpose served by the painting being consistent with the painting that's already been painted. This is one way in which a puzzled mind can try to figure out what Dworkin intended to do. But I believe that unless we take the work of Ronald Dworkin seriously, and unless we think of the need of judges who can be compatible with a judge like Judge Hercules, we can run into great difficulty, the sort of difficulty we ran into with ADM Jabalpur, where simply looking at what is good for society or what is felt as good for society at that given time by that number of judges living in circumstances where that seemed like an overwhelming opinion in favor of imposing restrictions on the individual, that the judges went along and did it, but obviously felt a sense of regret years later because the law had regressed by what they had done. And therefore, the Supreme Court in successive generations expanded Article 21, Maneka Gandhi's case, with the right to travel. And since then to now, Article 21 is now being described as an article of the Constitution rewritten by the Supreme Court, so that we have another positive Constitution written by the Supreme Court, completely, in a sense, different from the Constitution that was handed down to us in 1950. But as a last footnote there, even if 21 has been written and overwritten in the manner by the Supreme Court as it has, it's like the extension of the painting. It's not something completely different where, as some people say, the Supreme Court has clawed to itself the right that was of Parliament and has written a constitution that was the right only of the Constituent Assembly. That's not so. Think of the picture that I have just described, the picture of Dworkin, where you examine how the picture would continue. That's how Article 21 and the Constitution have continued in the supervision, as it were, and the creative inputs of the judges of the Supreme Court. And that's what makes the decision-making interesting, more than just being bureaucratic, more than just being legislative, a creative exposition of a reality that seems to exist somewhere in the ethos of our existence, but articulated in very specific way in the judgments that the courts give. And that's how I think judges decide cases. Now, I'm happy to take your questions.
Mr. Nachiketa, unmute yourself.
Okay.
Unmute.
Yeah. Can you hear me now? Yeah. Okay.
Yeah.
So I was saying, so thank you for this very interesting and rich insight into this entire discourse of how do judges decide cases. And indeed, what really catches my attention in that sense is that when I teach as a law teacher, this very interesting aspect that you have touched upon, that they cannot be perhaps what you call as the right answer. They can be best answer in the given circumstances. Then you must keep your methodology and the process intact for all kind of future findings as to where would you be able to find the right answer probably someday, right? And that's how in fact, my students all here, that's how I've also been mentioning that, you must have a well-founded legal reasoning for basing your answer of interpretation in the present day context. So that's wonderful, kind of a thought process. So thank you so much. And now the entire house is open. You all can ask questions to sir. I know they have been.
Allow me to recognize Justice Sikri, who is
Thank you.
who's
Thank you,
an
Salman.
exponent in a very special way of Dworkin, and therefore I think it's our honor that Justice Sikri is present.
No, Salman, it is your honor. When I came to know that you are going to give a lecture, and that too on the topic how judges decide cases. Although today I am no more a judge, but I still wanted to listen to you, and it was a treat, really a treat. I must say, a very nice. But I have one. Should I put one question?
Please, sir. Please, sir.
Yeah. You see, today's speech is primarily driven by Dworkin's approach. Now, one thing which
That's right.
really, we have to understand in this approach is, on the one hand, while giving this example of LGBT or NAS Foundation, you have said that how, of course, a very nice discourse on the policy versus the principles, and how the principles change and how they shape the society from time to time. So depending upon that, you have given the example that how at one point of time, it was treated as 377, was treated as offense, and the way we perceive privacy today, it is no longer, and the judgment in Naptej, which has come ultimately of the Constitution bench. Other example which you gave was of Lady Chatterley's lover, very rightly so. I also keep giving this example that today is because of societal norms which have changed, nobody is going to adhere to this kind of view, which is very clear from the fact that a movie is made and all these books, in spite of that ban, which technically continues in 50s or 60s, but there are, you can find the CDs of that movie, you can find the book really, which is sold across, and nobody bothers to execute that judgment. Yes, that has happened. But then Dworkin also said that when you asked, told the approach of Dworkin, that in hard cases, yes, he gave that distinction of hard cases, soft cases, etc. But ultimately his analysis was that every problem has only one answer. So once we ourselves accept that the answers may change, then how we adhere to his philosophy that the problems have only one answer, one solution. So the two things, sometimes they appear to be contradictory to each other.
Thank you, Judge. I think that's a very, very critical question. I think that what he says, if I understood him correctly, is that there is a method. There is a method that would take you towards the right answer, but at any given stage, you may not have the right answer because you may not have all the inputs and all the research that should be done to get the right answer, and that's the scientific process as well. That you do have research, and you come to a conclusion that this medicine can work for this particular disease, but the research continues, and it may well be that medicine is not the best medicine, that you would get a better medicine minus the side effects, etc., etc. So instead of seeing it as a contradiction, I think he sees it in a continuum, that you will continue in the right path if you pursue this path. If you take the other path, which is a policy path, then it's an open field. Then any kind of reply could come, any kind of decision could happen. There would be no integral method of approaching, whether the final decision is right or wrong, but there will be no method of approaching. And if you divert to another method, then the field becomes open and you could get all kinds of decisions. And therefore, I would argue that ADM Jabalpur perhaps was decided on basis of policy rather than on basis of principle, and decided on basis of policy, it's more likely to go wrong, more likely to lead to conclusions that may be unacceptable in subsequent generations. But I think, and I would encourage, encourage you, sir, to although you're not writing judgments anymore, but at least to explore this in a book so that we could all benefit, or we could all benefit from.
Salman, let me tell you, in other context, as a judge, when we have been going to judicial academies for the training of the judges, High Court judges and Supreme Court judges, from where you started in the beginning, that the judges normally they're conditioned by how they're bringing up in the society, of course, that is there, and their notions about a particular, their own personal views about a particular, and particularly it happens when we come to the issues of moralities in law, because everybody has its own perception, and which we call the biases of a judge in decision making. This bias is not that he has a particular interest, but his priors, P-R-I-O-R, priors, his thinking, that may influence, and how that should not influence. On that, I have been giving lectures from time to time, and how you should have to be more pragmatic in your approach, how it, although it is difficult, but how you can achieve at least to the maximum to remove these kinds of biases when you take. But that is one part. Coming back to this, only one thing more, that you rightly said that approach, and it is wonderful approach. As you know, I am also a fan of Dawkins, and he has said that when we try to think, when we try to, or judges try to ascertain the what is the principle, and you have used the word that there may be change in principle from time to time, societal, how society perceives of a particular principle. Now, there are some cases, and again, I'm talking of hard cases, which have not only moral tones, but it is very difficult to understand what is the today, the psyche or the thinking of a society. Of course, you have given the example of 377 or LGBT, but if we know that if we have referendum, even maybe 50% of the population may still say, no, it is not good. As you know, our all clerics, whether it was from Christianity or from Muslim community or from Hindu community, all they thought, no, it is wrong. It is something which is against nature and we should not accept. Likewise, take the example of Sabrimala, take the example of triple talaq. Now, here the society would be on moral values also totally divided. In such circumstances, how the judges approach, what should be the approach? Of course, in all these cases, the judges have ultimately gone to that, okay, these may be, but then we go by the constitutional principle. That constitution, as you have rightly mentioned about Article 21, also the way it is expanded. And they say that ultimately we go by what constitution says. But then again, that the interpretation of the constitution is also what they feel it should be. So how you reconcile in this moral, overly moral tone cases where the society is divided, and whatever a judge decides, in whatever form, there would be a criticism by one part of the society, and that may be a sizable society. You know, the kind of, as far as Sabrimala is concerned, we know that, and even Supreme Court has, this is the criticism of the Supreme Court. After giving that decision, then review comes, in review, then it is 3:2, then you refer to larger bench, then now it is referred to 9-judge bench, where totally different kinds of issues have been raised. And all this approach shows as if now the judges are, to some extent at least, come by what is the other view of the society, and we should have a fresh look into all these issues. So how you fit this scenario in Dawkins' theory?
Sir, I would think that this is really the core of the book that I'm suggesting that you should write. But for the present, what I would say is this: that the fact that a decision needs to be taken by the Supreme Court judge on LGBTQ or on Lady Chatterley's lover or on Teen Talaq or whatever else cannot be done, obviously cannot be done simply by doing a public opinion poll, because that may give some extra assurance to the judge, but that's not going to be the conclusive methodology for deciding one way or the other. But what I would really be very, very keen to hear from you is that when the court talks of constitutional morality, it seems to be focusing on the morality that is reflected in Article 21 and Article 19, but it doesn't take into account constitutional morality that includes 29, 30, 25, 26. Because the constitutional morality will come out of all that. It will not only.
So I was going
okay,
to
sir,
say that
so that's
only,
interesting. So
that I am writing an article
that,
and touching.
We've lost the link, I guess.
lost the link. Lost the link. Anyway, you know that there's an article coming. You
right,
at least know that you're.
So before we move forward, I will acknowledge my teacher and Professor Vijayakumar, Vice-Chancellor of National Law School, Bhopal, has also joined us on the screen. Good morning, sir.
Good morning. Good morning.
Oh, good.
Okay. Yeah.
Okay.
Good morning. Okay. Good morning, sir. Yeah. So we will take a few questions from here on.
Yes. Just Sikri is back.
No, I was
Justice
here only. I was
Okay.
hearing you. I was here only.
All right. Okay. He's there. So
Yeah.
you were talking about the article, sir. You were talking about what you're writing. You're just writing something.
Okay. I'll try then today itself.
You were saying something about an article that you were attempting.
No. I said that this on constitutional morality, the aspects which you are saying, highlighting of other articles of the Constitution, and even some other aspects of constitutional morality, I am writing on that nowadays, giving a different flavor, of course, or rather expanding that.
Expanding. We'll await it with great interest, sir.
Yeah, right. So there are a few questions up there in the chat box. I'll take them for you. One from Mr. Amit Yadav. That, sir, in a democracy where the lawmaking is the prerogative of the parliament, how far do you think it is the constitutional for the courts to make laws?
बैठे तो बात करो दो. Yeah.
So there's this one of the questions which is there in the chat box, that from Mr. Amit Yadav, that in a democracy where the lawmaking is the prerogative of the parliament, so how far do you think it's constitutional for the courts to make law?
No, I see. We would probably require more discussion for the courts to make law by way of legislation. I believe is wrong. But when courts make law, they don't make it by way of legislation, is what I believe is the correct position. They make law only in the sense that they discover law. They don't make law in the sense that Parliament makes law. And the process of discovery is what we have just talked about. Justice Sikri was mentioning it. It's the law that exists, as it were, that is unearthed by a judge through an analysis, and through an arrival at what shared values, which in more recent times have been described as constitutional morality. And if we understand what constitutional morality is, then the judges are not creating new law. They are actually discovering or uncovering what is the analytical conclusion that would be drawn from shared morality. So it's different from what Parliament does, and it can't be equated as Parliament. So judges, as Dawkins has said, are not deputy legislators filling the gaps left by legislators. They are not deputy legislators. They are, and this is an independent exercise that they have, which is a very valuable exercise of uncovering the inherent integrity of our legal thinking.
Yeah, maybe sir, we can bring in here perspective as Richard Posner sees judges as occasional legislators. Will that probably fit in as in this discourse of the debate? Well,
it's sort of, but I would still keep judges in a separate exercise altogether. They are like if you like when you have a sage or a saint who uncovers truth for you. The truth is not created by the saint. The truth exists independently of the saint, but the saint provides you assistance and in your ability to discover the truth. That's all the saint does.
Okay, right. Okay, so we'll take a few more questions, sir. There's one question which is here. So, sir, in this process of depending on the shared principles, sometimes judges go beyond the written word of the law. So how is this line drawn between what we call judicial activism and probably judicial indiscipline? But I would say maybe judicious overreach is what say.
I'm not at all worried about judicial activism at all. These are just descriptive ways of describing how a particular judge or a particular bench deals with an existing issue. It may see activists, it may be seen as non-activist, etc. So long as the method that I have described and I have endorsed, so long as that method is followed, it doesn't matter whether you are an activist or you're not an activist. That would be a matter of personality from a judge to judge, a matter of personality. Somebody would write more judgments, somebody would write less judgments, somebody would be more attentive, somebody would be less attentive to particular causes. But frankly, it's the method that is important. And if the method is correct, then the conclusions will inevitably be correct, although at any given time to say this is definitely the correct opinion would be wrong.
Right. Okay. So, so there are few hands, I think, being raised. Somebody who wants to ask a question. There's one more in the chat box here. That said, how do you see, as far as courts are concerned and prerogative of adjudication is concerned, non-conventional factors for decision-making like administration, political agendas, religious intolerance molds the reasoning of the judges in imperfections? How do these factors influence the deciding of the cases, such as religious?
These are matters that we shouldn't worry about when we are looking at an analytical approach. These are incidental issues that need to be handled in training. As Justice Sikri has just said, that when these people are taken out for training to the judicial academies, what should be diluted in their intellect, and what should be highlighted, and what should be strengthened and fortified, that the academies will do. I don't think that in this discussion this should distract us too much, etc., because this is all the training methodology, and then if you have a discussion on training, then this could be considered more extensively.
Okay. Yeah. So there's another question which is there, that in continuation of the present question, if legislature is having responsibility to make laws, then is it not contradictory to say that the principles of lawmaking and policies behind the lawmaking can always be the same. I think what are you trying to ask here? Somebody is the question is. I think the question is not clear, my dear friend. I have tried to make the sense out of it. You need to re-clarify the question. Okay, so we'll probably take the another one here. That
I'm just suggesting to you that since you're a virtual legal course, I would be very happy. I'd be very happy if you collect the questions that we haven't been able to because of technology issues, haven't been able to handle, and you send them to me by email. I will respond. I will respond.
That'll be great. Okay. Is there anybody who wants to ask can raise hands and I will unmute from my end? Mr. Ankit Goyal has raised hand. I'm going to unmute you. You can ask.
Hello, sir. Am I audible?
Yeah, go ahead.
Good morning, sir. Actually, I'm a law student at Law Faculty DU. So my question is, recently there was a order by Punjab and Haryana High Court that there was a bad mood in court. So please adjourn the court. There was a appeal by prayer by lawyer. So that was also granted by the honorable judge. So my question is how far this factor affects the decision making of a judge.
I didn't catch the first part of the question. In Punjab and Haryana High Court, so what happened?
Yeah, there was a prayer by an advocate in the court that please adjourn the matter because the court is in not a good mood. Court is in bad mood.
What is in a bad mood, Sujan? See, these are courtesies. These are courtesies of working together. These are courtesies of working together. I don't think that. I don't think that.
No,
too much should be made of it.
Salman, let me tell you. Because I have read that. What had happened was that the judge had dismissed 3 or 4 matters already, and when his turn came, he said that your lordship is dismissing all matters, so you are in a bad mood, so don't take up my matter today. So, so that was the reason. So the judge wrote, I have read that order because that was circulated on WhatsApp. I have read that. He said that, look, there was no merit in those cases, and that is why I have dismissed. That doesn't mean that I am dismissing because I am in a bad mood. But in any case, since you are having that perception, I'll adjourn your matter, and he adjourned that matter.
Okay. So we have next question going on there. Somebody with the name there on display is Redmi. Do you want to go ahead? I've unmuted you.
Yes, sir. Sir, this is Ali Ambedkar. Justice Sikri rightly pointed out that despite the judgments of the Supreme Court, say for example in Navtej Johar or Triple Talaq or Sabrimala temple entry, the struggle for values in society continues, which brings us to the point that every decision of the Supreme Court is representative of only a particular values embedded in a particular class of the society. So, don't you think that unless and until the Supreme Court is also representative of different classes of the society who carry different norms and values, then till then we will not be able to see just and reasonable decisions.
Do you want me to answer? I thought you directed that at Justice Sikri.
No, sir. Justice Sikri just pointed out this problem of irresolution of every conflict, because in society the struggle for power and antagonism is always on.
I have understood the question. What she's saying, that look, you see, let me tell you, you are going by the assumption that the judges are deciding because of their own personal views, and what she says, if that is the reason why there should not be composition of judges, that they should represent all kinds of views and all kinds of communities, etc. In that sense, she is saying, and that should be the composition. But let me tell you that that may be a wrong approach in looking, because you cannot presume that the judge has decided because this was his personal view. As we said, in these cases also, as well as, of course, there are dissenting judgments in all the such cases, except yes, Tej is where it is unanimously on 377, all 5 judges has decided. But Sabri Mala also has witnessed dissenting judgment, and Justice Indu Malhotra gave, and in Tripat Talaq also Justice Nazir and Chief Justice Kehar gave dissenting judgment. So therefore, the views would be there. Of course, there would always be discussion who is right, who is wrong when there is because dissent has its own value. And we have seen, and these are very example which Mr. Salman Khurshid has given, that at one point, and that is the value of the dissent. And the history is replete, even not only in other countries, but India also, where one particular view was taken by the majority, and there was a dissenting view, and dissenting view became majority after a few years, overruling the earlier judgment. So therefore, those things would be there, but we have to go on the premise and on this basic position. So this is what I was saying. I mean, this may not be a correct approach.
But sir, a quick rejoinder, if I may.
In the appointment of judges.
But a quick rejoinder, sir, from taking the experience of American Supreme Court and American Realist School, where white judges decided that blacks under the Constitution are not conceived to be citizens in that Scott case, and similarly, many other. Is the Supreme Court of India going to follow the same pattern of the U.S. Supreme Court, whereby it is going to pronounce that different classes do not have rights under the Constitution because the Supreme Court is constituted in a particular way? The composition is loaded in favor of particular classes.
No, not you see, my answer was not that there should not be representation. There should be, right? We talk of representation of women judges on the bench, and there should be more and more. That's a different arguments altogether. But linking it with a particular judgment, and because the composition was that, I was only answering that. We have to see, and normally the judges are deciding, applying that methodology which Salman has in his brilliant lecture has said. And I would say, yes, many judges would be oblivious of this kind of system and how they should decide, and what Dwarkin has said or laid down. And my personal view is that yes, judges should also read all these aspects to hone their own skills. And it can be in the judicial academies also, as Mr. Salman Khurshid has said. But that is a different aspect of the matter. Ultimately, the appointments, of course, we have to give representation, but the appointments have to be on merits. Not that it's not that where some particular slot have to be reserved, like in the services, that 15% to reserve for SC, ST, and 15 or 20% reserved for women category, or in some say based on even the religion, etc. Of course, it is, if you see, the attempt has been made in last many years that there should be representative judges from all these communities as well. Attempt is made, but ultimately selection should be on merits. This is what I'm saying.
Right. Thank you, sir. So I hope that gets answered. I'm going to unmute Aditi Mittal. Do you want to go ahead and ask the question?
Sure. Good morning, Mr. Khurshid and Justice Sikri. I'm Aditi. I'm a practicing lawyer. I had a question regarding, how we read how Supreme Court is taking suo motu cognizance of various cases or general issues that are prevalent in the society, or issues that are being faced. So I just wanted to ask a question: and how does the Supreme Court or any court decide when they want to take suo motu cognizance or action in any of cases? Is it something that pricks their judicial conscience, or how does it work? Just for everybody's benefit, I thought I'll ask.
Okay, thank you. This is directed to
Justice Sikri, I think.
Justice Sikri, right?
Would be
right person to answer this.
You see, you are right. Normally, the normal perception is, and that is the principle also, that the judges don't invite the cases or the disputes, they are brought by the outsiders or the parties at their doorsteps, and they are supposed to decide. Then they cannot shy away, and they have to decide if it is brought. And therefore, in the process, taking a suo motu notice, but then simple answer is there can be a long debate. You see, it all started with the PILs in Justice Bhagwati's time, when he said that those issues which are the issues where the issues of moment, and where issues concerning social justice and fundamental rights, those who are either poor or who are either illiterate and they cannot approach the court, they cannot access the justice. Why not a third person, a right-minded person, can bring a cause on their behalf? That is, relaxing the rule of locus standi, which we call. And when this started, they said that, oh, look, we will entertain even the postcard. But then over a period of time, so the first was that anybody can file the petition. Second was that, okay, no formal rules of pleadings, etc., that you have filed petition, you just write a letter, will take. And third step was, okay, when a judge himself or herself thinks that some issue, and even after reading a newspaper, that, okay, this needs the attention of the court started doing so. But having said so, I would say that the judges should restrain themselves and may pick up only those cases which really come within the category of PIL that was initially thought of or envisaged by the PIL court, that on behalf of those who cannot approach the court, and the issues are relating to the fundamental rights of which are violated, etc., of these poor and marginalized section of the society. It should be limited to that, if at all it has to happen.
Thank you, sir. Thank you, Aditi. Paramita Chattaraj, do you want to go ahead? Ms. Paramita Chattaraj.
But ask the question to Mr. Salman. He is the speaker today, and I'm not.
I
am also one of the listeners.
Exactly. Yeah.
Yes.
Good
morning to you all. Good morning, sir. Sir, this is Dr. Paramita Chattaraj. I'm here speaking from Bhubaneswar. I'm myself a law teacher. I was just wondering, going through the composition of bench, I'm just reopening the discussion that was just going on a few minutes back, that the judge in Saira Banu case, where the five judges, they were all belonging to 5 different communities. But the point that I want to make here is, isn't this beyond the very point that judges should not be, or appointment of judges or fixation of judges should not be based on any of such criteria like race, religion, caste, or gender, because they should be bereft of all forms of subjective notions, and they should represent the chair which would be all in all fairness would dispense justice. So the fact that a judge bench of the judge is fixed, where representation is being made from all the religious orders, that shows a kind of compulsion in which the judiciary is working, which itself is, I think, some kind of a pressured situation. I just want your input, sir, in this regard.
You want Mr. Salman Khurshid to answer, or just?
Well, please understand that that we are all in the situation which is a human situation. We are not machines. We are not computers. There is no artificial intelligence that's functioning. We are human beings, and human beings have sentiments. Human beings have inherent limitations, but we assume that when someone reaches the level of a Supreme Court judge, that those things are diluted to the maximum, and that the training and the self recognition itself, self-esteem, makes them function in a manner in which these considerations are become irrelevant. Scholars may still find that these considerations in one way or the other have mattered. But why are you talking about only factors that relate to religion or language or caste? What about factors that relate to education, that relate to your upbringing, that relate to your economic status, etc., etc. There may be many factors, and that's where the American Realist School takes a lot of these things into account. But I think that, again, as I said for Dworkin, it's a process. As long as we are in the right direction, we are moving in the right direction, it's fine that we move away from prejudice and preconceived notions to an open mind and an objective mind by training, by self-esteem, and by experience and by history. And I think that's what we've attempted in our constitution, and that's what we've attempted in our Supreme Court. Whether for specific benches, specific judges should be placed, I think is more to do with sending out right messages to the public that you are not unrepresented. Someone who would understand in a special way your concerns and your conditions would be there to share with his colleagues whatever these special considerations and special concerns may be. It isn't that nobody would be informed about your feelings. Your feelings would be. It's done by, it's an exercise, if you like, of confidence building, that you should have more confidence in this court. But these problems arise only in our court. They don't arise in courts like the UK, Canada, and the USA, where the entire Supreme Court sits for all cases. We have a problem that the Supreme Court has to sit in benches. So somebody may find fault with this bench or that bench, but I think it's very marginal. And this is something that we should look on the positive side rather than on the negative side. This is how I think this could be answered.
Right. Thank you, sir. Okay. Dr. Parikshit, do you want to go ahead from Delhi University?
Yes, sir. Good morning, sir. This question is directed towards Mr. Khurshid, sir. Sir, I teach constitution law at Delhi University, and sir, I completed my PhD from Jamia. There is something which has been bothering me, and you've touched upon this in your lecture, which was very, very erudite. You spoke about the Sabrimala issue. You spoke about matters of faith. Now, we constantly hear somebody saying that matters of faith, courts should interfere. Somebody says you cannot interfere. Somebody says you should not interfere. Sir, my question is specifically on Article 25. Sir, Article 25 uses 3 words: profess, practice, and propagate. What is your view on those 3 words one by one, sir? And do you feel all 3 words should be there, or do you feel one of the words should or should not be there? Because that is what is creating the problem in my view, sir. Thank you, sir.
I think that the Justice Sikri should answer this because he never
Any
had
one of
to
them,
answer
sir.
this on the bench. Now there's a chance. Now there's a chance to answer.
I think this is totally going to be a totally different debate, and it will be a long drawn debate. It is not related to today's topic. So we'll
because
tell
it is
Nachiketa to have a separate session on this, and we can debate on this.
Right. Parikshit, we can do it later, I guess. Right?
Absolutely, sir, if you
We
so
can do it,
wish.
yeah, but thank you for sharing that.
We'll flag this for another day.
Right. So, Indra Devi, I'm going to unmute you. Can you quickly ask and be to the point, my dear friends? Be concise, and please focus on the subject matter of the discussion today. Indra Devi, you can go ahead.
Thank you, sir. My question is directed to Khurshid, sir. So my question is about methodology. You mentioned about how methodology can inevitably lead to a better conclusion, the conclusion. So my question is about how do we decide the methodology? Is it based on the question of policy versus principle, or is there any other thumb rule that goes along, in finding the right methodology? Thank you, sir.
See, there are different schools of jurisprudence, and there are different judges who've written about how they decide cases. So it's a matter of study, and we pick the right strands from all. It will be difficult to prescribe, as it were, one one clear methodology when there are judges who are satisfactorily working with different systems and different methodologies. But as I said, there will have to be some acceptance of a broad distinction between decisions based on popular morality and policy, and decisions based on something different, an analytical conclusion about our fundamental beliefs. And when I say this analytical conclusion about fundamental beliefs vis-a-vis popular morality, etc., I think some of these factors would be reflected in the Sabrimala judgment, where the lady judge, Justice Indu Malhotra, who one would have expected would be in favor of women being able to access the temple, was the one who said that if there is a sense and belief in the sect that women should not, of a particular age, should not access the temple, then we should preserve that, and we should respect it. Whereas it was the male judges, the men judges, who said no, women have a right to enter. So I think you read the judgment carefully, you would find this interesting interplay of policy and principle. And I'm quite certain that Justice Indu Malhotra's judgment, which was by way of a dissent, is a judgment that is based on an analysis that is more towards the principle analysis rather than the policy analysis. And I suspect that the majority judgment does have a larger element of policy than one would normally believe a judgment of principle would have. But I think this is an interesting judgment to study and read, and certainly one would be very curious and interested in what the larger bench of the Supreme Court will now do.
Right. Thank you so much, sir. Krishna, do you want to go ahead? Krishna Bhattacharya, I've just unmuted you.
Farid. क्या होता है? हाँ करो अप्लाई करो ओके
Yeah, Krishna, do you want to go?
अप्लाई करें बिकॉज़ हमारे यहाँ एक आ गया है.
Hello, Krishna, can you hear me? Do you want to go ahead?
Yeah.
Okay, I think I would have lost link.
It takes 2
Okay,
days.
Shazia, I'm going to unmute you. You can go ahead.
The app takes 2 days.
Good morning, sir. My question is actually during a recent webinar by Harvard Law School, where Professor Richard Susskind said how online courts are going to be the new future of justice being delivered. And we also see a part of that being in our own judiciary system as well, due to the current COVID-19 pandemic. So what I would like to know is, as aspiring advocates, as aspiring lawyers, is there a difference that has taken place in the interpretation by the judges? Now, the current scenario, so in the virtual courts, is it different from what we have in the physical courts? Is there something that we as budding lawyers should be aware of it? What we can expect from the coming transition?
Well, thank you. My little experience before digital courts still is in the process of a learning curve, and I'm quite sure that judges are experiencing something similar. What one has seen is that at present judges think that only very urgent short matters can be dealt by them, whereas larger matters, and we are accustomed in our courts in India to argue at length, particularly in the Supreme Court judgments that arguments can go on for days on end, that may yet not be a comfortable thing on the digital mode. But I think that technology will improve, and our experience will give us better understanding, both sides, the bench and the bar. And then we will learn to do this in a better way. Now, the American Supreme Court yesterday heard digitally a matter in which the entire court sat, all the 9 judges sat. Whereas in our case, 2 or 3 are sitting, and it is a little bit difficult. It is a little bit difficult for them, sometimes. So it's I think it takes some time. I believe that Justice Sri Krishna has given a lecture on digital hearing adjudication. I haven't seen that lecture yet, but I will try to access it. So I think this is work in progress. It's too early for us to be able to predict how things will go. There are people who are concerned that digital courts do not allow the open court situation to be sustained, because only the lawyers who are arguing are there, whereas the rest of the country or rest of the people are not able to access it. But that's a matter that can be solved through technology. But we have to be ready now for tomorrow's world. We have to be ready to do things digitally. So as young lawyers, try and I'm sure you'll be better at it than most of us who've been accustomed to personal appearances. But I do feel that face-to-face arguments and being able to see reactions of judges, and judges being able to see the demeanor of the lawyers, etc., have an extra quality which is missing at present, at least in digital performances. So let's see how it goes.
Okay. Yeah, thank you, sir. Can we take 2 more questions if you permit? Okay.
Yeah.
Dipanshu, I'm going to unmute you. Please be concise, so as clear as you can.
Good morning, Salman sir and Sikri sir. I'm Dipanshu Bhatta. Sir, my question is, as far as the Singh Johar case is concerned, although the only issue was discrimination of consensual sex between same-sex persons, what I think is in other incidental rights, as per the constitutional morality, hanged in the middle. As per the offences in criminal law and the marital offences and the matrimonial rights and all. I need some insights of you in regard to this.
Well, you see, this judgment is just the beginning of a process. This judgment is limited. It's not an endorsement. It is not an encouragement. It is not it's not a broad agreement with complete change of the moral landscape, but that there is a clear indication that we are shifting from positions of the past to new positions. Now, as I said earlier, is this shift based on policy? Is this shift based on principle? I am hoping that this is a shift based on principle. And if it's based on principle, it will take us much further and much beyond the judgment in the near future. If it's a matter of policy, then there may be some difficulty. In between, let's remember that when the Nas judgment was given by the Supreme Court said, this is not for us to do, i.e. we are not applying any principles. This is a matter of policy. Please take it to Parliament. But then the subsequent constitutional bench has taken a different view. And I believe that different view is largely a principle-based view, and therefore we have a chance of moving forward. Now, this relates to a particular specific matter, specific case, but related issues or issues that can be considered equally important in terms of marital relations between sexes, between people, etc., will be handled in due course as and when the cases come up to the courts. But we need to understand whether it's to be done on policy or on principle. And I believe that moving towards the principle is the right thing that the courts are doing.
Thank you. So we'll probably take one just last question. Pawan, do you want to go ahead? I have unmuted.
Good morning, sir. Would you suggest?
Good morning.
Pawan, where are you from?
Sir, I'm currently based in Dubai and I'm from Andhra Pradesh. I'm doing my master's in LLM in international business law. So would you suggest a few books as young lawyers that we need to read to hone our skills, please?
Your voice is not clear, Pawan.
Could you
Not
just
audible.
Yeah, we can't hear you properly.
Sir, is it audible now? Sir? Apologies for the inconvenience.
No. Maybe you can type it in the chat box. I'll see it from there and ask.
Yes.
Okay, then we can probably take Kalyani. Want to go ahead?
Yes.
Just quickly.
Good morning, present here. Sir, in your lecture, you pointed out that judges are opinion. They decide sitting.
Kalyani, we can't hear you. We can't hear you, Miss. Yeah, we can't hear you. I'm so sorry about that.
Very bad connection.
Yeah, your connection probably is not working. All right. Okay. So no problem. Yashvi, I'll just take your question and probably we'll finish it off. Yashvi, you can go ahead.
Good morning, sir. My question is to Salman, sir.
Yes.
Sir, since you have such a rich experience in advocacy, could you tell us how and to what extent can an advocate influence the way a judge decides a case?
Oh gosh, you're asking the wrong person. But Justice Sikri is there. Let me just give you one personal, very pleasant personal example. Many years ago, during the time of Justice Bhagwati, I attended as a very young lawyer. I attended a conference at which a very significant and important judge from the Australian High Court was present. And after I finished my presentation, he gave me a compliment. He said, "Am I glad that you don't appear in my court, because I would have decided in your favor unfairly." And I thought that was a very good compliment that was paid to me. But I think that judges do get influenced by presentation, and that's why presentation is made. But the influence that comes on the judges is a fair influence. It's the influence that you can have between a teacher and a taught. How do you explain something that normally there are judges who come who know exactly what is required to be done, but they still test the lawyers in front of them by saying, no, come on, tell us what is there in this, etc. Some judges don't read anything. Justice, I do remember quite often one of the Supreme Court judges used to say, "Please tell me what this case is about," because they followed the English judge's approach. I don't want to make up my mind before I come, and therefore I will hear you, and once you explain, I will be able to appreciate what exactly you want. So the manner of presentation, and this is what we are educated about and we are trained about, is extremely important to put across to a judge, because it's like a teacher and a taught relationship. You can read a book, but you still need a teacher. Similarly, a judge is well equipped to decide without your presence and can decide, but I think the presence of the lawyer makes a great deal of difference, and the repartee between the judge and the lawyer is extremely important. It helps you discover and learn as a lawyer, and it helps the judge in making up his or her mind as to what he should be doing.
Thank you, sir. So I've just received one question on my WhatsApp, which appears to be such that when senior counsels, they have been practicing at the bar for such a long time, they have the understanding of how do judges decide cases. So does it give any edge or a headway to the senior counsels to get their cases decided in a particular way, or can it make it a little easy for them in some sense?
Well, after years of practice, there are some seniors who don't seem to understand how judges decide cases. No, always come outside court and complain about why they didn't get the relief that they deserved. But frankly, I think that advocacy is an art. It's a very important art, and if you're able to refine it, and if you're able to learn it well, it makes life for the judges a lot easier. And they appreciate it, and their appreciation is for you and for your self-esteem something good. And in any case, if you've been a lawyer for a long time, you should be sitting on the bench as a judge rather than continuing to be a lawyer.
Right. So on that note, so thank you so much, sir, for sparing time today on my request, especially for my students of interpretation.
Thank you very much, and thank you to Justice Sikri.
No.
Justice Sikri has added so much flavor to this.
No, I think it was your personality which attracted me to hear this, and I feel that yes, these 2 hours or 1 hour 45 minutes are well spent. Thank you, Salman.
Yeah.
Thank you.
Thank you so much, Honorable Justice Sikri has been very kind. Salman sir, when I shared with Justice,
be safe, everyone. Please.
Yeah, everyone.
I have a lot of takeaway as a teacher of interpretation of statutes today. So I hope the students would have.
Okay, good. I'm glad.
Thank you so much, sir.
All the best.
Thank you, everybody.
Hope to see you again. Okay. Bye-bye.
Thank you.
Bye-bye.
Thank you, sir.